That's why everyone's so careful up there. You don't point the guns that you know are not loaded in your direction, because you know that things happen. People get scared. In this case, his gun was loaded. In this case, this individual has just walked in, gun is out. Even if he hadn't pointed it at his head, that's reasonable apprehension. According to him, they just showed it to him. Even though it was for the dog's benefit, they just kind of showed it to him. He did the swipe. Remember he told you that? Doesn't require that it be pointed right at him. He admitted that that's what he did. But he went further. He actually touched him. And when he touched him on the left temple, you can imagine the absolute terror. That is absolute apprehension to the nth degree. It's the definition. If you look it up, that's probably what you'll see. And you have the injury that corroborates it. So there is reasonable apprehension. And did he use a handgun? Of course. He admitted that he did. Well, how about the animal? How about June? The crime of cruelty to animals requires that the state prove that the defendant intentionally or knowingly, well, he did it intentionally, killed the dog. Did it intentionally. And this dog is in the care and custody of another. Yes, it was. It was in the custody of Daniel Rodriguez. And he did it without legal privilege or consent of the owner. By his own definition, the owner was getting in the way. So it's in the disjunctive. Without legal privilege or consent of the owner. It's not in the conjunctive. In other words, you don't have to meet the legal privilege. But did he have a legal privilege to kill him? No, he didn't. It doesn't work for the SPCA. That's what legal privilege talks about. When they say legal privilege, it's when you find a dog that's been hurt on the side of the road and you call the Society for the Prevention of Cruelty to Animals, or you call the Maricopa County Dog Shelter, and they come out there, they have a legal privilege to euthanize dogs, even though the owner says no. He does not work for them. He works for the Phoenix Police Department. This issue of legal privilege does not even apply. That is not here. And did he also do it without the consent of the owner? Absolutely did it without the consent of the owner, according to him. Well, the crimes are committed. But he sat before him and kind of cried and wanted you to believe all in self-defense. All of this. Everything was in self-defense. Well, let's talk about self-defense. Because it tells you that this is not a case of self-defense. And I emphasize to each and every one of you that this is the law. Irrespective of how you feel about police, irrespective of how you don't feel about police, irrespective of how you feel about the law, whether you agree with it, whether you don't agree with it, your duty is to follow the law. You have no discretion. That was one of the things that was asked of you during the jury selection process, whether or not you would be able to follow the law. Well, it says a police officer is justified in threatening or using physical force. We're now talking about the first incident, the aggravated assault, when the defendant walks in. That's what this applies to. A police officer is justified in threatening or using physical force, the gun, against another, Daniel Rodriguez, if in making or attempting to make an arrest or detention, that's what they said they were doing. They said not arrest, but it's a detention, or in preventing or attempting to prevent an escape. He wasn't in custody, so they weren't attempting to prevent an escape. Such police officer, Richard Chrisman, uses or threatens to use physical force, and all of the following exists. It says all of the following exist. It doesn't say one, it doesn't say two, it doesn't say three, it says all of them exist. And number one, a reasonable person, not Richard Chrisman, a reasonable person, not a reasonable police officer, a reasonable person, someone with common sense, someone who sits in a jury and looks at day-to-day living. It says a reasonable person would believe, that reasonable person would believe that such force, getting the gun out, is immediately necessary to effect the arrest and detention or prevent the escape. By definition, by his own admission from the witness stand, this doesn't apply. Because remember, he said the reason he got the gun out was not to affect the arrest or detention or prevent the escape, because he was still, at this point, remember, walking in. He hadn't made any decisions. There wasn't anything going on. Remember, he said that he was doing it for the purposes of scaring the dog. Well, if he wasn't doing it to affect an arrest or detention or prevent an escape, that first element is not met. And there is no self-defense in that case involving the aggravated assault. The other issue for him, is it immediately necessary? Is it immediately necessary that he put this gun to Daniel Rodriguez's head? Not according to their expert, Ron Bartel. The way it works is you first try this verbal judo stuff. You talk to the person first. Then you may use, for example, hands-on. That's how it works. That's the staircase, if you will, to deadly violence. Then after that, you may use OC spray, a taser. And then, and only then, to affect that detention and arrest, do you use that. He did not stop at verbal, did not do the OC spray, did not do the hands-on, and did not do the taser. He went immediately to deadly force. But is it immediately necessary that he do that? No, not at all. It wasn't immediately necessary to the officer. And remember, it's a reasonable person. Does a reasonable person believe that such force is immediately necessary? You walk in the door and you immediately need to put a gun to somebody's head. It is if you're Richard Chrisman. It is if you've had a conversation with his mother and you've told her, you really can't understand what she's saying. And that just goes to his attitude that day. No one's saying anything else other than that's his attitude. And then you take off and leave your partner behind because you can't wait to get in there, even though you've left your cartridge behind for your taser, even though you didn't even take your taser, much less bring it fully equipped. And so, that's what this individual did. He wanted to get in there. Is it immediately necessary to affect the arrest or detention or prevent the escape? No. It isn't. Not at that point. So there is no justification. There is no self-defense with regard to that. Well, is there self-defense that involves the dog? Let's see. According to him now, self-defense is because the dog, according to him, this dog that's far away is coming at him. Is he saying then that the dog is a deadly weapon or dangerous instrument? Because that's the only way you can use deadly force. But if you look at the crime involving the dog, it says that the crime of cruelty to animals requires the state to prove that the defendant intentionally or knowingly killed a dog in the care and custody of another and without legal privilege or consent of the owner. Well, he's saying it's self-defense. He's saying the dog was coming at him. But it doesn't have anything to do with detention. It doesn't have anything to do with arrest. And it doesn't have anything to do with preventing arrest. So this section does not apply to the dog. Because at that point, that's not what he's talking about. Well, let's go over to the one that involves the use of deadly force on the individual. Let's talk about the one that he believes justifies the use of deadly force against another. The one where he took the gun and shot him. That's at the top of page 8. And a police officer may use deadly force against another only when the peace officer reasonably believes that it is necessary. And it says, you must measure his belief against what a reasonable police officer would have believed. And a reasonable police officer in this case is Sergio Virgilio. Did Sergio Virgilio believe that it was necessary to shoot him? To shoot somebody as they're walking a bicycle out? No. He doesn't get to dictate everything. The jury instructions tell you that you must measure his belief against what a reasonable police officer would have believed. In this case, the difference between this case and many others is you have another police officer whose reasonableness has been presented to you, who was in the same situation as the defendant, who was walking in the defendant's shoes in that trailer. That's a reasonable officer. That officer who began to talk to this individual, Daniel Rodriguez, and Daniel Rodriguez began to comply. And so, you don't take his word for it, even though he wants you to just have belief in what he says. You don't take his word for it. There's another officer, a reasonable officer who's there, who says, no, that wasn't reasonable. And so, this is not a justified killing. But we can look at it further, and it tells you that it's available to defend himself or a third person from what the officer reasonably believes to be the use or imminent use of deadly physical force, or to effect an arrest or detention of a person who the peace officer reasonably believes, and then there's three modifiers, has committed, attempted to commit, is attempting to commit a felony involving the use or threatened use of a deadly weapon or dangerous instrument. B, is attempting to escape by the use of a deadly weapon or dangerous instrument. And the past or present conduct of the person, which is known by the peace officer, that the person is likely to endanger human life or inflict serious bodily injury to another person unless apprehended without delay. Well, this requires, under 2, that the individual, Daniel Rodriguez, have with him a deadly weapon or dangerous instrument. All three of them indicate that. Daniel Rodriguez did not have a gun, so he doesn't have a deadly weapon. They're going to say to you, well, it's a dangerous instrument, that bicycle, don't you know? All those people that are in the Tour de France, potential murderers, I have, you know. That's what they want you to believe. Everybody in the Tour de France, look out for them. You've seen them as they run, other people run by them, and then the bikes are coming at them. That's 40, 50, 60 miles an hour. Those people, well, they haven't. Those people are just looking for a murder charge. Well, what is a dangerous instrument? It tells you. A dangerous instrument means anything that is readily capable. Well, a knife is readily capable to cause injury. A fork maybe, a screwdriver, a box cutter, a sledgehammer. Those are readily capable of causing death or serious physical injury under the circumstances. For example, you just don't see somebody with a knife while they're eating a steak and say, oh, that's a dangerous instrument. No, they're using it to cut their steak or they're using it to cut their chicken. So it's under circumstances in which it's used, attempted to be used, or threatened to be used. Well, what about this case? Indicates to them this bicycle is a dangerous instrument. One of the things that you first have to look at is the item itself. Kind of bulky, you're going to have it back there, and it's kind of not very maneuverable. The way to move it from one place to the other is to roll it. If you roll a bicycle from one place to the other, it's not going to cause too much harm, because as we see with the Tour de France, that's what it's meant to do. And that's what was happening in this case. What else about it? Well, it does have pedals, but those pedals come at you at an angle so that you don't really know what's there. Whether or not those are coming at you or not. You do have handlebars on it, but again, they're not pointing like a knife or anything like that that's going to come at you. They're not like that at all. So, is that readily capable? Is that something that is really capable to cause death or serious physical injury? No. How about just something about the wheels turning? No. In fact, that has nothing to do with indicating that this is a dangerous instrument. It is the state's position that a bicycle is not a dangerous instrument, because it is not readily, the phrase is readily capable. How many people have had their bikes fall on them? Many people. Did they die from that? If there were a motorcycle, you would have a different argument. But a bicycle? How many people crash when they're out there on their events? Lots of people. None of those is indicated. None of those events are readily capable of causing death or serious physical injury. So you have this bicycle, and he's telling you, well, the way it's being used, that's the key here. He has to, of course, because you have to believe because of the medical evidence, he has to have the bicycle standing up this way. And the bicycle, at least at the seat level, is approximately 3 feet. A little bigger, 3 feet. And it's a little bit higher at the handlebar. And one of the things that happens when you lift those is that they're kind of hard to grab, because once you do that, the front tire or the handlebars turn, kind of clumsy to grab that way, the way that he's describing it. But he has to have the hands up like this because of the stippling evidence. He can't have the hands here, he can't have them here. He's got to have the hands up here. And it takes quite a bit of strength to get it all the way up here, because the hands have to be up here for it to make sense and for him to have belief. But the problem with that, and something that he forgot, you know, with the truth, as I said before, with regard to the truth, he ain't got nothing to remember. But he has a lot to remember. And one of the things that he forgets is that when he's got the bicycle up here, it's not a bicycle that's all the way through. It's got these wires that come through. It's got a tire. It's got bars that go back and forth. It's got a seat that goes through. And he's got this bicycle right here that doesn't leave him room to explain why we have such a nice stippling pattern here in the chest. It ignores the fact that the stippling pattern is there and it doesn't have any voids. So even if he tells you that, number one, it couldn't have happened that way. It couldn't have happened that way because of the stippling pattern. It just couldn't. And that would have required him, without invading anybody's space, to be much closer than 3 to 6 feet. I'm sorry, than 3 to 5 feet. It would have required the gun to be closer, if you will, because there is this intermediary thing that is picking up the stippling in order to get this same pattern. The bicycle would have had to be much, much closer than the way that he describes it. Either way, those particles that are traveling ahead of the bullet, the gunpowder that is traveling ahead of the bullet, that are 2,000 degrees, that are like a dust storm, would have damaged the part that they hit. You can look at the bicycle yourself, and you can see that there is no defect. There are no defects to that paint. There is no bullet shot either. There's no scraping of any paint there. There is no stippling on the bicycle. And in addition to that, there is no voids, if you will, here in the chest where the shot went through. No way that bicycle could have been up there like that. Believe that it did. He wants you to believe it. The other problem is that, remember, it has to be readily capable of causing death in the way that it is used. Mr. Rodriguez can't just have a bicycle up here. He's got to have it in a position of readily capable, i.e. in action, ready to move forward. And if he's moving forward, even if you shoot somebody, the person goes down, but the motion continues. I'll tell you about the bike falling right, and it never did. It's impossible for the bicycle to have been used in that fashion that he described. The forensic evidence says it wasn't. The medical evidence says it wasn't. And it just makes no sense that this individual could raise it so high and hold it up like this. Why not just push it that way? But he wants you to have faith. To this faith, there's a standard. And this standard is beyond a reasonable doubt. And that tells you that in this case, standard is beyond a reasonable doubt. And proof beyond a reasonable doubt. Everybody has heard it. There's proof that means you're firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. In criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced of the defendant's guilt of any of the crimes charged, you must find him guilty. What this tells you is that the doesn't have to be a perfect case. In other words, the state does not have to prove this to you with absolute certainty. The law does not require proof. That overcomes every doubt. It's just beyond a reasonable doubt. And that's the standard that is applied in this particular case. Is there any doubt that he's the person that shot Daniel Rodriguez and killed him? No. Did he do it intentionally? Of course he did. Did he do it with premeditation? Yes, the state concedes that. The aggravated assault. Beyond a reasonable doubt that he's the person that had the gun in his hand? Absolutely. Beyond any doubt whatsoever that if an individual comes near you, and again, I don't want to invade anybody's face, and they come at you very quickly with a gun, any doubt that would cause you some apprehension or cause apprehension? Absolutely. And did he do it with a gun? Yes. And do you have the corroboration? Yes, you do. He did do that. Beyond a reasonable doubt. And beyond a reasonable doubt, he shot the dog. There's no reason to shoot the dog. No reason to shoot it. The dog was far away. So against that, beyond a reasonable doubt, has he been able to show you that he's justified in using this particular form of deadly force? No. He made it up. He made it up with regard to the bicycle because the forensic evidence does not support what he told you. He tried to get help from his friends who were moving things around and they were talking about aphids, but it doesn't change the fact that he did not. It could not have happened the way that he said. Forensically speaking, or medically speaking. You take a break now. You have a break, or do you want me to take it?
I don't know. Are you close to finishing?
No, I got maybe 30, 25 minutes. 30 minutes. I'll go ahead if you want me to.
No, you answered my question. Ladies and gentlemen, we'll take the afternoon break at this time. Please remember the admonition, keep an open mind. Don't discuss the case. At 3:07. Jurors are excused. It's 3:08. What?